Welcome, everyone, to the Wagner Law Group's Fall Benefits Briefing, and thank you very much for joining us today. This is one of our periodic webinars where we like to report on issues of interest, kind of some hot issues and things that are happening in the world of benefits and throughout the retirement industry. We're very pleased to have you with us today. I want to remind you that if you have any questions during the course of our webinar, please make sure you take notes. You'll be able to email us directly or reach out to people you know at the firm, and we'll be glad to respond. And also want to let you know that this will be recorded and posted on our website, so that if for some reason you want to follow up on a point or you had to trail off and leave a minute early, you'll be able to follow through and hear the rest of the content. We have an interesting agenda today. As you can see, we'll be leading off with with a discussion on our legislative, regulatory, and policy practice. Our strategic partner, Chris Condalucci, who many of you might recall, from his practice here in D.C. and his former role as the Benefits Counsel on the Senate Finance Committee, will lead us through a discussion on some things that are happening in the world of legislative activity and kind of how it's done behind the scenes. And that will be followed by Tom Clark, our partner in our St. Louis office, on some current hot issues on Department of Labor audits. We're seeing a lot of DOL activity in the audit world. We want to talk about that a little bit. Then we're going to go to some issues in multi-employer practice from Izzy Goldowitz in our DC office, our partner there, and that'll be followed by a discussion of some issues on retirement MEPs from Susan Reese, also in our DC office, and some current hot issues in the executive comp world from Mark Perio on the latest happenings there. I'll finish up with a quick update of discussion on some things that are happening around the Fiduciary regulation, but we'll focus primarily on regulation best interest and specifically on what people could or should be doing right now to prepare for it. Okay, so Chris, let me hand it over to you and ask you to take us through your thoughts.
All right, thanks so much, and thanks everybody for tuning in today. Very appreciative of the Wagner Law Group folks for including me in this webinar, as well as our strategic partnership as it relates to doing more work on the policy side. As many may know, as Steve mentioned, I had the fortunate opportunity to be Benefits Tax Counsel to the Senate Finance Committee, left the government and still do both legal and policy practice in my current practice, and I want to try to bring what I know and my expertise and my skills to WLG, as well as take advantage of the technical expertise that WLG has here and that provides to all of you. And I'll actually pepper in one of the reasons why I think WLG is such a great firm and why a strategic partnership between both of our firms is going to help all WLG clients as well as future WLG clients. So what I have is I have a couple of slides here that I want to talk through, and I'll just note this. I mean, some of it might seem elementary, to be honest with you, but you know what? What I want to talk through is a perspective that you oftentimes don't hear from folks, because at least in my simple mind, there is a particular perspective, or better stated, there's a particular strategy that an organization, a client, a company, a nonprofit, a government-based organization, what have you, it runs the gamut. There is a lobbying strategy that I believe is an effective one. There's a number of different strategies that folks can adopt, but again, I feel that a more effective strategy is one that I will talk through. And at the end, I'll be open for some questions from Steve, and then we'll keep moving through the slides onto some of the technical stuff. So here, the first slide you see in front of you is this effective lobbying strategy. And what I stress to my clients and what I want to stress to WLG clients as well as future clients is, look, when you are lobbying, you need to talk to the right policymakers. And what do I mean by the right policymakers? In truth, it is not the actual member of Congress. It is not the actual senator in the Senate. The right policymakers, at least the way that I define it, are congressional staff that works for a committee of jurisdiction, a leadership staff, either in the House or Senate, either Republican leadership staff or Democratic leadership staff. Also, you want to get in front of staff working for senior members on the committees of jurisdiction, and you want to talk with champions of a specific issue. And just, again, focusing on this, talking to the right policymakers for a moment, why am I mentioning who I at least think are the right policymakers as opposed to telling you that going to an actual member of Congress or an actual senator is the way to go? Because where the policy is written, where the legislation and the technical expertise that goes into writing legislation starts with the committee staff. And the committee staff are legislative committees, and that is where all of the policy and the legislation is written. So if you want to get something done in Washington, D.C., if you want to get something done on Capitol Hill, you want to go to the committee staff of the committees of jurisdiction. What do I mean by committees of jurisdiction? Well, it's the committees that have jurisdiction over the issue that you care about. So, for example, retirement, exec comp, that's tax related. So that falls to the House Ways and Means Committee, which is the committee of jurisdiction over tax, and Senate Finance Committee in the Senate. Finance has the jurisdiction over tax. Health benefits, that's going to fall to the House Ways and Means Committee, the House Education and Workforce Committee. In the Senate, that falls to the Finance Committee as well as the Health, Education, Labor, and Pension Committee. Those are the committees of jurisdiction, and you want to talk to the committee staffers. Also, you want to talk to leadership staff, and when I go through my slides, I'll actually tell you why. I won't tell you just yet. And again, it makes sense when I tell you staff working for senior members of a committee of jurisdiction, because not only do you want to get to the committee staff, you need to get to those committee members to push your agenda, to be supportive of your policy change, of your legislative proposal that you want committee staff to write and start processing through the committee process, which again, we're going to talk to. So continuing on this slide, but to go to my second sub-bullet here, lobbying is 90% education. It literally is 90% education. And in my opinion, you should not go into an office and say, I want you, congressional staffer, to do this, or I don't want you to do that. To me, that is not an effective way to lobby. Instead, the better way of lobbying, a more effective strategy, is educating staff about who you are and what you do and why you are a good actor in your respective industry. And that brings us to this next slide, where what you want to do is you want to educate staff on your business model by explaining, and you can go back one more slide, Steve. Business model, why you're a good actor, and why do you want to do that? Because you want to build up your credibility with staff and you want to get them to know you. So when you do want to go in and talk to them about, hey, I don't want you to do this, or hey, I do want you to do that, they're going to listen to you because you have already built up your credibility with them. You've already got the staffer to know you and to generally like you, and it is so much more effective to take that tack as opposed to airdropping in on a particular issue and saying, I don't want you to do that, or I want you to do this. Now, the second sub-bullet you see here in this slide is you also want to position yourself to be a trusted resource. You always want to be helpful to staff, and this really segues into my last bullet here. As a staffer, I craved data. I always wanted to hear what other people were doing because when you're a staffer, you're in your ivory tower, like literally. I don't know what's going on out in the industry, so I need people to come in who I trust, who I know knows what's going on in the industry, and who I believe is not going to be shoveling something and just telling me stuff to tell me stuff. I need to trust them, and it's those trusted resources that I want to get the data from. And as you position yourself as a trusted resource, you get the staffer to know you, you could share that data, and that only helps you in the end. Go to the next slide for me, Steve. One of the things about lobbying the federal departments is you don't lobby the federal departments in the same way you lobby Congress, the way that I just described to you. Really, instead, you actually do go in to the federal departments when you do want something, or basically don't want something, but it's more you're going in when you want something. And just like talking to congressional staff, you've got to explain your business model and why you're a good actor, et cetera, to build up your credibility. But you also need to go into these meetings with a game plan and specific legal arguments as to why you want the administration to do what you want it to do. And why is also that important? Well, not to minimize congressional staff at all. I was a lawyer when I was a staffer. Most of the committee staff and leadership staff are lawyers. Some personal staff are not lawyers. But when you're talking to an administration official, typically they're lawyers, and it's more of a lawyerly, technical environment that differs from when you're talking to congressional staff about policy and different changes that you would get through legislation. So you need to be more precise in your legal arguments, be more precise in your pitch. You don't have to focus as much on your business model and why you're such this good actor, but you do need to explain what you want and why you want it in terms that those administration officials can understand, and then they will likely, or unlikely, but more likely, and that's why you're in there advocating, effectuate what you want. And as I state here, there are other times where you are going to play defense, which is something you're going to hear from Tom and others when it comes to audits. So go to the next slide for me, Steve. Now, when it comes to process, right, like sausage is made, you know, one thing that if you're going to adopt some sort of lobbying strategy, or if you're willing to kind of take the plunge into trying to get known on Capitol Hill, try to increase your visibility and credibility, and potentially get something done in the long run, you know, it takes a long time because anything getting done through Congress takes a long time. And as stated, you can't quite airdrop into a particular issue out of the blue. It doesn't really go over well with staffers. Instead, you've got to make the commitment. You've got to commit to educating. You've got to commit to being that trusted resource. And that, again, takes a long time in addition to just Congress itself taking a long time. So one of the things that you see at the bottom of the slide here is if you do have an industry-based piece of legislation that you want passed, nowadays in Congress, that piece of legislation doesn't get enacted on a standalone basis. Instead, it's included in a larger must-pass piece of legislation. So while advocating for passage of the legislation on a standalone basis, which is what you got to do, you must also advocate for the inclusion of this legislation in a must-pass vehicle, because that, for right or wrong, is the way that the process has been going in Congress. Go to the next slide, because this really puts it in perspective and allows me to talk about leadership staff here for a moment. So again, while advocating for passage of your industry-specific legislation, it's more likely to get pushed into a must-pass vehicle, and you need to talk to committee staff, like I mentioned, because that's where the legislation is written. But you know what? You then need to build support, not only with rank-and-file members, but with the leadership staff, which you see is my last bullet here. And again, why is that? Because leadership staff is the one who really decides what goes into a must-pass piece of legislation and what doesn't. So if you have laid the groundwork with committee staff and you've helped them write the legislation, you've talked to senior members of the committees of jurisdiction, you've then talked to committees or leadership staff, that is, to say, hey, I'm working on this piece of legislation with committee staff and I want it to get passed. But you know what? If it doesn't get passed through Congress as a standalone piece of legislation, I want it to get included on this must-pass piece of legislation. So can you help me get it done, leadership staff? And again, if you build your credibility up with each of these players, you're going to have more likelihood of finding success. Again, which is a much more effective lobbying strategy than you might hear from others. Now go to the next slide for me, which is generally the last slide for me. Which talks a little bit about, again, the federal departments and distinguishing lobbying the federal departments versus lobbying Congress. Well, just like Congress, it takes a long time to get something through the departments, as we all know, but there are indeed opportunities to influence the process through the federal departments, through face-to-face meetings, through public comment letters, through requests for legal clarifications like PLRs, advisory opinion letter requests, SEC no action letters. There's also interactions with the White House in the Office of Management and Budget, because OMB also has a say over what is going through the federal departments and what those federal department officials are working on, either on your behalf or, let's say, in an interest that is adverse to yours. There are opportunities to influence the process through White House and OMB as well. So again, it's my trying to distinguish a little bit of federal department advocacy versus congressional advocacy, but the bottom line is, and I'll close on this, is there's an effective way to lobby and I think an ineffective way to lobby. And I think I've walked through with you what I believe is an effective lobbying strategy, and one that we here at WLG and hope to incorporate into WLG's practice. And I hope to leverage all of the technical expertise as well as my own expertise that I bring to the table to provide excellent services to, again, existing WLG clients as well as future ones. So with that, Steve, I'll turn it back to you.
Oh, thanks. Hey, let me ask you a quick question, because I think, I'll put lobby in quotes. Lobbying is a term of art. It's kind of a magic word. It conjures up different images and different meanings to lots of people. Now, our firm has a legislative, regulatory, and policy practice. You have a legislative practice as a component of what you've done in Washington. Can you just very quickly explain to people the difference between when and why one would register as a lobbyist versus when and why one would exert, influence or be a resource and provide support to a federal agency, that is considering, a proposed legislation, a proposed regulation or an interpretive position?
Yeah. When it comes to lobbying Congress, if you're going to touch a congressional staffer, and what I mean by touch is you're going to sit down and meet with them, it's advisable to register as a client that is working with WLG from a lobbying perspective just right out of the gate. Although you might be going into that congressional staffer on an education-only basis, building up your credibility, et cetera, you're still touching that congressional staffer, and in time you're going to be advocating on one thing or another. So whenever you pull the trigger on, yes, I want to start talking to congressional staff, WLG should and could and would and will register as a lobbyist on behalf of that client. When it comes to talking to the federal departments, it's a little bit different. If you're talking to certain levels of federal departments, you technically don't need to register as a lobbyist for that. There are certain administration officials that under the Lobbying Disclosure Act requires registration. But as a general matter, if you're going to touch the federal departments, it's also wise to register as a lobbyist, because at the same time you're touching the federal departments, you're going to be touching Congress primarily, or that's what I recommend that you do. So the bottom line is register as a lobbyist if you ever are going to pull the trigger on doing it.
Hey, thanks. I appreciate that. Of course, as I said before, our firm is a registered lobbyist, and in fact, we have current activity with you on some legislative proposals in the retirement area. There are other areas in our legislative, regulatory, and policy practice, like, for example, Susan Rees and Izzy Goldowitz, who you'll hear from shortly, filed some very well-received and well-publicized amicus briefs on some issues in the appellate courts recently, and that's not you're lobbying in effect to the extent that you're standing up and speaking about a policy, but it's not one that requires registration per se. So I just wanted our listeners to appreciate that lobbying can mean a lot of things to different people, but as a technical term of art, there are certain times when one registers as a lobbyist and other times when one simply participating in the professional community and trying to, exert influence or be a resource on policy or court decisions, what have you. So thank you very much, Chris. Really appreciate that for walking us through. And it's really a pleasure to be partnered with you in this practice area. There we go. Tom Clark, how are you today? And I'll just turn it over to you to walk us through some of your current thinking and experiences on DOL audit investigations.
Thanks, Steve, and thanks everyone for dialing in and listening today. Our firm is increasingly representing clients in investigations by the Department of Labor. The Department of Labor increased their efforts under the last administration. And while we were taking bets when this administration came in that they may be reducing the number of investigations they start and conduct, you would have lost that bet if you would have guessed against it. This administration has been just fine to continue many of the enforcement efforts of the Obama administration. So we're seeing these investigations centered everywhere. We currently or have recently wrapped up investigations out of the Kansas City office, the Chicago office, the Atlanta office, the Boston office. The DOL is active everywhere. So they not only are going after our plan sponsor clients, meaning our employer clients, they are also going after and investigating our investment advisory clients. And we've even heard rumors that they are investigating our third-party administrative clients as well. And the thinking there is instead of going after just one plan, when they investigate the records and books of a fiduciary investment advisor, they can get at 10 plans, 20 plans, 50 plans, 100 plans. So what we wanted to do today is give some back for those of our clients who have never gone through this process, make it a little less scary, give some insights into how these investigations go from beginning to end, give some tips for what happens when they start and how to prepare for one before you ever get the letter. So what are the reasons for a DOL investigation to start? What is told to us by the folks who do this at the Department of Labor, on the record, off the record, is that the majority of investigations start from participant complaints. The Department of Labor has a 800 number and great resources on the phone that can discuss with participants about different issues related to their plan. People call all the time and make complaints. And so that is the number one route. Next is referrals from other agencies. So if the IRS were to conduct an independent audit of a plan and see something, they will cross-refer to the DOL. DOL will cross-refer to the IRS, just the same. Enforcement initiatives. The DOL has always had, or at least in the last few decades, had enforcement initiatives that are very familiar around late contributions. The department, it never seems to slow the number of plan sponsors they find who have issues getting their employee salary deferral contributions in on time. And so the DOL has different enforcement initiatives built around different issues like that. They have an ESOP, an employee stock ownership plan initiative, and then they have some other initiatives. These initiatives are listed on their website. We don't have enough time today to get into it, but I would encourage you to go to the DOL's website and look. Another way, Form 5500 issue spotting. If you report, well, first of all, if you're late filing a Form 5500 repeatedly, or you have to file amended 5500s, or you forget to file your audited financial statements, that is a red flag, and they will likely be knocking on your door sooner rather than later. Our understanding is the same way that if you were a family of 4 and made $80,000 a year and reported to the IRS that you made $40,000 in charitable contributions, more likely than not, the IRS will eventually knock and say, hey, that's outside our bell curve of normalness, right? Most $80,000 a year families don't contribute $40,000 in charitable contributions. You're going to get a knock. So if you put numbers on your plan 5500 that don't make your Form 5500 that don't make sense for your plan, the DOL has algorithms they run, and you are likely to start an investigation. The last one we'll talk about today is media, meaning if the DOL catches a newspaper article that a business is going bankrupt, or there's other shenanigans going on with a business owner who may have stolen from the company and so on and so forth, that will put the Department of Labor on notice about that employer, especially in the bankruptcy context, because if that employer goes bankrupt, it's likely that there is an abandoned plan in there. So all the reasons for the DOL investigation start, they will not tell you when they call, but most of the time after we're retained, we can make some very informed guesses. Steve, next slide, please.
Okay.
Just so that people are aware, this is the map of the different EBSA regions. EBSA is Employee Benefit Security Administration. That's the sub-level agency inside the Department of Labor that's responsible for ERISA and regulation of ERISA-governed plans. DOL has lots of different sub-agencies DOL even does things like regulating mines. So this is the sub-agency responsible for ERISA and retirement plans, or ERISA governed retirement plans. So me in St. Louis, I'm governed by the Kansas City office. I think there used to be a small St. Louis depot, but now there isn't anymore. But again, wherever you are, wherever the plan administration is conducted is typically where the office that, if you were to receive an investigation, that's where it's from. I believe they would tee off of the address that's reported on the 5500. All right, Steve, next slide. So what does the process look like? It'll either start with a phone call or an initial letter. Oftentimes just an initial letter. They will, I think, very rarely just show up, although I've heard instances where that does happen. They will knock on the door, but that, I think, is reserved for very special situations where maybe there is a great chance of loss or fraud or criminal aspects of it. But typically, it will start with an initial letter introducing the investigator, that the plan has been selected for investigation, and attached to that letter will be a significant document request. The two recent ones of the clients that I'm working with, one had 20 requests for documents, the other one had 34 requests for documents, individual requests. So for example, provide us copies for the last 4 years of your complete plan documents, copies of your summary plan descriptions, copies of all the 408B2 disclosures you've received since 2015, for example, through the present. So then the next process is you produce documents to the Department of Labor, sometimes in advance electronically or by paper, sometimes on site for the interview. It really depends on the investigator. There's no set method. Then the next step, of course, is on-site interviews. The investigator will come out and typically likes to meet at the location of the plan sponsor, typically where the plan is administered and where there might be other documents and so on. Investigations can last anywhere between 12 and 36 months, depending on how much they find or what issues arise. I think the golden average may be, in our experience, about 18 months from beginning to end, as long as there are no serious issues or serious negotiations over anything identified. And then it will end with a closing letter, either that nothing has been found, or if something has been found, it will give you an opportunity to fix it, and then the DOL will typically go on its way. Next slide, please, Steve. So how to respond if you get a letter. Take a deep breath. Right, I've had clients call me hyperventilating over this, some on the verge of tears. My frontline experience in working with our clients who receive DOL investigations is that it seems far scarier on the front end than it actually ends up being. No one likes the federal government to come in the front door of their businesses, but I have yet to interact with a Department of Labor investigator who is anything but courteous, professional, and frankly just wanted the same thing that most plan sponsors want for the participants, which is to have the plan run in their best interest and run well. So take a deep breath. It's not as bad as it seems. Second step, put your team together and choose one person as the primary contact. I've seen this before we get involved, where things kind of can get off the rails because different people have different responsibilities, and so different emails are being sent and different phone calls are happening, and there isn't a strict flow of information through one channel. So choose one person as the primary contact. Of course, we're biased in this respect, but we believe this should be ERISA counsel. We always strongly encourage ERISA counsel, mostly because we have such experience in this that we can make it go smoother. We put the investigator at ease. We speak the same language generally that they do, where plan sponsors may not speak, quote, the ERISA language. And so we think we just grease the process and make it smoother and can just make it more efficient and hopefully end it faster. I often get the question from people in the audience or clients, if we bring in an ERISA attorney, doesn't that make them think that we're guilty of something? And the answer is no. They're going to do their investigation no matter what. They're going to do it to the best of their abilities no matter what. And I have never seen a letter from the Department of Labor saying, well, you brought your attorney in and therefore here's 30 more document requests and we now think you're a bad person. I think that's just people being fearful. As I mentioned before, some of these document requests can be quite lengthy. In my last investigation and my most recent investigation since that started in March, we have produced over 50,000 pages of documents. That was the one with the 34 individual requests. That does not include raw, like Excel files with lots of data on contributions and so on, but 50,000 pages of just PDFs. We've done it all electronically, which is great because it keeps the cost down, but can you do that in 10 days, which is typically what these letters ask of you to return that around? Probably not. And so being respectful, you reach out to your investigator, you let them know that you'll start immediately to gather these documents. Of course, you have them well organized wherever they are, but we need additional time to request, and I have yet to ever have an investigator be unfair in responding to those requests. So then after you have your extension, get organized, put together a plan. Again, if the ERISA attorney is involved, they're going to be the ones who can assist. You need to perform a review of the documents prior to production. I think one of the worst things that can happen is if you produce something with an obvious error under the fiduciary guidelines and you don't self-report it and then the department finds it, it just makes it more uncomfortable and seems like you don't know what you're doing and can add to their findings that again, that you may have breached or you don't know what you're doing. It's always better to self-report. So for example, if we review the contributions and we see, we had 3 times in the last 3 years that we were late past what is administratively feasible, we just go ahead and tell the DOL on the front end that we found this, and it's usually very easy to fix. Always present the documents in a neat and organized fashion. When they're neat and organized, that presents a picture that you're neat and organized and that you had a neat and organized fiduciary process. And then finally, just always be truthful and respectful. This is, even though it seems confrontational, it is not, or it is not traditionally. Don't be rude. Some people I've seen or have heard, of course, we've all heard horror stories and war stories about how these things go down, and it's just not like that. You must be truthful at all times. If something wasn't right, tell them it wasn't right if they ask. But at the same time, you also don't want what I call a chatty person answering questions. So in the sense that if the DOL asks, did something happen in 2012, and you say no, but it happened in 13 and 14, that's not the right way to answer that question. The answer to the question is, did something happen in 12? No, it didn't. Right? Did we have late contributions in 2012? No, we didn't. You don't necessarily have to volunteer information that they don't ask. So on that, Steve, I think that is my update for plan sponsors and other listeners on DOL audits.
Oh, great, thanks. You're talking about, the role of counsel, and is it sort of an admission of, gee, I'm really in trouble, I brought my lawyers versus helpful. Susan Reese and I are involved in a fairly substantive DOL investigation right now. It's been going on for about 3 years. But we were just brought in within the last year, and I think it's an example, to use your, like you mentioned before, where the issues can be so complicated, the documents so hard to trail. We're crazy ERISA people, right? We live and work in this area, and we know it well. And I think in this case, we were able to help at least clarify and illuminate the issues and close the gap on some pretty significant misunderstandings between the client, several of its remote offices, and the regional office. I'm not going to say what city it was in, but the regional office. It's funny also, the enforcement manual for the DOL, if you read it, they instruct, it's funny. A lot of it depends on the relationship you strike up with the investigators or the people out in the field. I've always generally had good experiences and found people, to be, courteous, professional, like you say, just trying to get to the facts and do the right thing. The enforcement manual from the DOL does say stuff like, it does tell the investigators that, every subject or interviewee probably knows more than they initially admit knowing. That's right out of the manual. So they are trained on investigative techniques to kind of prompt information, and it's good. I think it is good to to be cooperative, but also to know when to answer and when they might be out of bounds or whatever. What do you think, Tom? I mean, for plan sponsors that are not currently under audit But, you know, maybe in the back of their mind, they're wondering, did I quite get this right? Did I handle this revenue share properly? Gee, did I really make up for that lost contribution in the proper way or fast enough? For people, what should the default position be? How do people know that they're ready to go? What should they do now if they, just to be ready in the event they ever are audited, or if they think that, you know, maybe I have a little issue here that's lurking around that might be surfaced, you know, over the next year or so? What should plan sponsors be doing now?
Well, I think there's two parts to your question. On the little issues, always address them sooner rather than later, because there's voluntary compliance programs you can participate in to self-report and fix before the DOL comes in, and those become unavailable when an audit starts. And so that's sort of the second half of your question, that if you do think you have an issue, go find out if it's actually an issue and get it resolved sooner rather than later. Don't bury it. But the answer to the first part of your question is what can they do now? I'll tee it off of I had 2 back-to-back full days with a client and a DOL investigator, and it came down, one of the most interesting things that came out of the experience was the investigator expressing to us how helpful meeting minutes are. And, you know, they said to us, listen, I see that you have benchmarking reports. I see that you have quarterly reports. You have an advisor. You did all of these great things. I can see the process. I can see the substance, right? I can see that you were paying attention to revenue sharing and share classes, and you were swapping out this fund and that fund. But what I can't see without meeting minutes, or what helps me as an investigator with meeting minutes, demonstrates the plan sponsor's knowledge of how you did this, right, and why you did this, most importantly. This investigator expressed to us, that's very important as part of my investigation, to come in and not just be presented a bunch of documents, but to feel good and know as part of my report that the people sitting in this room have their minds wrapped around how this plan is run and why it's run the way it is, and why it's run in the best interest of the plan participants. And I thought that was an incredibly insightful comment from the investigator, and a very fair one at that. And it reminded me of a quote that I pulled from a recent case. It was a Third Circuit case in one of these 403B lawsuits. And here's the quote that I think sort of puts a fine point on this recent experience that I had. The court noted, a fiduciary's process must bear the marks of loyalty, skill, and diligence expected of an expert in the field. It is not enough to avoid misconduct, kickback schemes, and bad faith dealings. The law expects more than good intentions. A pure heart and an empty head are not enough. And that pure heart and empty head comment, or any good ERISA litigator cites that all over the place. That's been cited for 30 years. But I think it puts a point on the issue in that sometimes it's, you know, not enough just to avoid doing bad, but you have to show that you were purposefully doing good. And the only way to do that is to document how you were doing it and why you were making that. And this investigator said that comes in the form of meeting minutes. It's incredibly helpful to me to see that you had that knowledge. They also believed it was incredibly helpful for the fiduciary, of course, to understand 2 or 3 or 5 years later why they made a previous decision. And so they are able to recall it and understand it and not lose institutional memory over previous fiduciary decisions.
Okay, well, thanks for sharing those thoughts. I think it goes without saying for people in the audience that when you get a DOL letter in the mail, I don't know that it's obligatory to answer. You might choose not to respond and wait for a subpoena or some other formal action, but it certainly is wise to, I think it's the much better course of action to respond to these letters. So thank you very much for taking us up on what's happening in the world of audits. Izzy, I'll kick it over to you to brief us on some things that are happening in the multi-employer plan practice.
Thank you, Steve, and thanks to everyone listening. The topics I'm going to discuss, I think, will be of interest both to employers who are in multi-employer plans or considering acquiring companies who are involved in them, and to representatives of plans themselves. As you know, multi-employer plans cover 2 or more unrelated employers under collective bargaining agreements. They're often called Taft-Hartley plans. Since 1980, Congress established withdrawal liability in the 1980 amendments. Withdrawal liability is an exit fee that represents an employer's fair share of the plan's underfunding when it leaves, either by going non-union or by ceasing operations. In my experience, and that includes being in-house counsel to a multi-employer plan, these plans have always been aggressive in pursuing withdrawal liability, and rightly so, because of the trustee's fiduciary duties. I want to address one area in which the plans have been quite aggressive, and that's pursuing remote parties under an expansive view of the definition of employer. For example, you may be familiar with the First Circuit's decision in Sun Capital versus New England Teamsters Pension Plan. That was a preemptive suit by a private equity fund who had been assessed liability because of the withdrawal of a portfolio company. And it sought a declaration that it was not part of the ERISA controlled group and therefore not jointly liable for the withdrawal. The fund prevailed in the district court and also on appeal. The question there was whether a private equity fund could be a trade or business and therefore potentially a controlled group member that would be jointly liable for withdrawal. The case was then remanded because the PE fund in question owned only 70% of the portfolio company. There's an 80% threshold. However, on remand, the fund succeeded in showing that two related PE funds together owned 100%, one 70%, one 30%, and on the facts had operated as de facto partners, and therefore their ownership interest could be aggregated, and they met the 80% threshold, and were therefore jointly liable. That case is on appeal again, and argument is scheduled for October 7th. First Circuit, as you may know, covers Massachusetts, Maine, New Hampshire, Rhode Island, and Puerto Rico, but this is a very closely watched case nationwide. In several circuits, plans have also succeeded in holding asset purchasers liable for withdrawal as a successor employer. Now, you may know that successor employer doctrine is quite common in labor and labor law and various branches of employment law, and ERISA is no exception. The Ninth Circuit is one of several circuits that have recently expanded successor liability in the withdrawal liability context, and a recent case, I think I have the citation wrong. It's actually the Heavenly Hana case versus Hotel Industry of Hawaii Pension Plan. The court there held that a successor, to be sure, must have notice of the liability, but that ordinarily one would expect a buyer to have notice by virtue of the due diligence it conducts before purchasing the target company. As well, in the case of a public company, there will be public information disclosing pension liabilities. So I would say this about cases like this. One might think give a wide berth to any multi-employer plan or any DB plan for that matter. Not so. My takeaway is that with a proper understanding and proper counseling, one can find value in companies that participate in multi-employer plans, but it's just a matter of knowing how to properly value that liability and then how to take advantage of it in negotiating the purchase price and the other terms of purchase. And this is something on which we advise quite frequently. Next slide, please, Steve. Okay. Valuation interest assumptions. Some of you may be tempted to take a nap at this point. And I know it sounds a little boring, but I assure you this is a money issue, so please do stay awake. Withdrawal liability claims often involve multiple issues, and to my way of thinking, it's important to figure out which are the real money issues and then figure out how to best leverage them in a settlement. Most of these cases do settle, but behind it is the threat of litigation. So what's going on here? Withdrawal liability is the fair share of the underfunding, and to determine underfunding, you first have to value the liabilities. That is, take decades worth of future payments and present value them. Many funds use their funding assumptions, which are based on an equity-like rate of return, but many funds now are blending those funding assumptions with what's known as the PBGC assumptions, the assumptions that are the interest factors that are derived from annuity prices. Needless to say, insurance companies are far more conservative in valuing liabilities, and such a blended rate would therefore give you a lower discount rate and a higher present value and a larger claim. This issue's been, the validity of that has been litigated recently in two cases, one, the New York Times case, and second, the Manhattan-Ford-Lincoln case. Manhattan-Ford was not appealed. The Times was. It was actually argued in May, and I understand that the case has recently been settled. So we will not have a Court of Appeals case on the validity of a blended interest assumption anytime soon. Please note, though, that the issue is pending in a case called Energy West Mining Company in the District of Columbia, and reportedly the issue is also pending in several arbitrations. I would say this issue is lurking in just about every withdrawal liability case that I've worked on, whether it's in arbitration or in court or just in the planning stages. And again, it is a money issue, and so I would urge you to pay close attention to it if you have any withdrawal liability exposure. Next slide, please. Okay, which leads me to the last point, which is that when Congress enacted withdrawal liability in 1980, it actually helped to shore up these multi-employer plans and save many of them. And the system worked for quite a few decades, but over time, many plans became unsustainable. Why? Industry obsolescence, offshoring, decline in union membership, longevity improvements, that is, people live longer, and investment losses. You may recall that most institutional investors suffered huge losses in the last recession. So in 2006, Congress required troubled plans, the so-called yellow and red zone plans, to take steps to right the ship, to attain healthier funding levels. Those steps included increasing contributions and reducing certain benefits, such as subsidized early retirement benefits, but even that was not enough in many cases. There are more than 130 plans that are in what's known as critical and declining status. That is, they're projected to literally run out of money in the next 20 years. Those plans are authorized to cut even basic benefits and pay status, but there's a process that involves an application to the U.S. Department of the Treasury and a participant vote. There are about 1.5 million people in those plans, and these benefit cuts, of course, threaten their well-being and that of their dependents. But beyond that, keep in mind that most income that retirees have is almost immediately spent on the necessities of life, and therefore there's a multiplier effect. Retiree spending, by some measures, has a multiplier effect of more than 2 to 1, supporting other jobs and supporting the economy. The House has recently passed what's known as the Butch-Lewis Act, which would finance these plans and allow them to restore benefits or maintain benefits at full plan level. But of course, not for free. It would essentially do this through federally subsidized loans and expanded PBGC assistance, which in turn would require higher premiums paid to the PBGC. I think it's unlikely to pass the Senate in its present form, but it is a stake in the ground. I would say this. This legislation, should it pass, will have a great effect on many constituencies, not only employees and retirees and organized labor, but businesses, both large and small. And I would suggest that Congress should keep in mind the interests of small businesses who provide most of the jobs in this country. They will be significantly affected by any compromise legislation that might pass. And Steve, back to you.
Yeah, thanks. So, I mean, so as we sit here today, what do you think? I mean, do you want to? What's your political calculus on the Butch-Lewis bill?
Yeah.
What do you? I mean, as we sit here today, what's kind of going on behind the scenes? Like, you know, what's really happening. Just, quickly, because we want to try to keep moving through the time. But maybe you or Chris have some comments, what it looks like, what it feels like around this issue or this piece of legislation in the Hill right now.
Right. Well, to state the obvious, the House is dominated by the Democrats and the Senate is dominated by the Republicans, and for that reason, I would suggest it almost certainly would not pass the Senate in its current form. I don't have any, calculus as to how likely the Senate might do something, how likely it is the Senate might do something, or so in what form. But I think that at some point between now and the lame duck session at the end of next year, a compromise package might emerge. Chris, I don't know. What are your thoughts on that?
My quick take is, just like anything, there's a lot of politics involved with multi-employer pension plans and the proposed relief. Interestingly enough, this White House, unlike previous White Houses, understands that something needs to get done and some sort of help needs to be provided, even if that happens to be government-related help. I think all of this, though, spills into next year. It's a political issue. It's a political year. The White House understands that they need some of the Rust Belt states, if I could call it that, but at least maybe better stated, the central state states. And therefore, I could see the White House being more open to some sort of proposal that's government-related or government-backed relief. Whereas, as Izzy just mentioned, getting it through the Senate is going to be difficult. So this spills into next year for sure, and it could very well be a political issue going into the campaign and nothing happening until after the election. So how do you like them apples?
Thanks. Well, I thought we were talking about how to make sausages, not apples, but I understand either way. Thanks. Okay. Hi, Susan. We're ready to hear about recent developments with MEPs.
Thank you, Steve. My remarks are for advisors to small employers, or perhaps small employers who already provide employee benefits through a multiple employer plan or are considering a MEP. As background, prior to 2018, the Department of Labor had recognized only one type of MEP as a single ERISA-covered plan, and that was the association plan. That stems from the ERISA definition 3.5. Definition of employer includes a group or association of employers. The DOL interpretation has always covered both group health plans and retirement plans in the same definition. As of 2018, the DOL provides a new definition of association plan for group health plans, popularly known as AHIPs, or association retirement plans. Now the Department of Labor has provided two types of retirement MEPs that are single Title I plans, and a third type, the open MEP, may be on the way. Steve, you want to, next slide. The DOL MEP regulation, we have the details of it in our Wagner Law Group client alert of September 11th, so I'm not going to go in great detail, but the new regulation provides safe harbor rules for the association retirement MEPs and a new safe harbor rule for a PEO retirement MEP. And the regulation has an effective date of the end of this month, but as I go through the slides, I'll let you know, there are three details in the association MEP definition that were also in the AHIP association rules that are in litigation, so we may have 6 months before the association retirement MEPs are really clear as to whether you can use them or not. Next slide, please, Steve. The first type of retirement MEP is the association retirement MEP, and it has some rules you'll recognize from the test for association plan that the DOL has always used, but some new ones. First, for the first time, the group or association can have the creation of the MEP as its primary purpose, but it's required to have at least one other substantial business purpose that's unrelated to the MEP. And then other rules, each employer has to have at least one common law employee in the MEP, and the group or association needs to be controlled by its employer members and the MEP itself needs to be controlled by the employer members that participate in the MEP. Next slide, Steve. The other primary requirement that you'll be familiar with from the old DOL guidance is that the employer members are supposed to have commonality of interest, and that has always been defined as being in the same trade or industry. In the AHIP reg, and again now in the new Retirement Association MEP, those employers can also have geographic commonality in the same principal place of business in the same state or metropolitan region. This reg also clarifies, even though it's always been clear to the Labor Department, that the group or association is not going to be a commercial entity like a bank, trust company, insurance issuer. Next slide. A new element that was first provided in the AHIP reg is also in the bona fide retirement MEP, and that is that working owners, these are individuals with no common law employees, they can participate in the association MEP in their role both as employer and employee. And you'll see the rules in the regs. The individual has to have an ownership interest in the trade or business, and then there's a minimum income requirement, and the fiduciaries for the association retirement MEP are supposed to keep tabs on this. One interesting requirement for the retirement association MEP is that the working owner has to make enough income to provide AHIP coverage for his employees if the association, his or her association, actually sponsors an AHIP. So the caution is that on the working owners issue, also having the MEP as the primary purpose of the association and the geographic commonality expansion of the commonality test, these are three elements that are in the AHIP litigation. And Wagner Law Group, as Wagner Law Group with Chris Condalucci, we filed amicus briefs in this case, and we are expecting a fairly rapid resolution, but it obviously will affect the association retirement MEPs as well. Now, the PEO retirement MEP, the definition of the PEO, that's the professional employer organization. It's a human resource organization that contractually assumes substantial employer functions on behalf of its client plans. Those of you who've wrestled with the common law definition of employee or employer, what's known as the Darden test, will recognize some of these elements for the PEO as Darden light. The PEO is not treated as a common law employer, but has some of the attributes. And one of those attributes in the substantial employer functions is that the bona fide PEO will be the plan sponsor, the plan administrator, and the named fiduciary. And that the PEO is going to have obligations to the participants, even if the client employer is no longer contracting with the PEO. And again, like with the association retirement MEP, PEO has to make sure that each employer has at least one common law employee in the MEP and makes sure that the participation is limited to just the employees or former employees of the clients or the PEO. Next slide, please. Oh, next slide too, sorry. And we've done that one. Next slide. The substantial employment functions are primarily defined as the PEO assumes responsibility for and pays wages and employment taxes, regardless of whether the receipt or adequacy of the payment from the client employer. The second major part is that the PEO plays a contractually defined role recruiting, hiring, and firing workers of the client employers who adopt the MEP. And what you can read from the reg and from the preamble is the hiring and firing requirement looks a lot like the Darden test, but the regulation makes it clear that the client employer really has that authority, and the PEO doesn't actually have to exercise this authority as long as it's in the contract. So you can go to the client alert if you want more details, or to the reg itself for more details on either one of those two types of retirement MEPs. Steve, do you want to do the next slide? I'm not going to spend too much time on the DOL request for information, but at the same time that it issued its regulation on the retirement MEPs, it issued a request for information as to whether it should redefine the retirement MEP to include open MEPs. An open MEP is defined as a single defined contribution retirement plan that covers employees of multiple employers who have no relationship other than their participation in the MEP. You can read through the DOL RFI. I'm not going to spend too much time on it because it's very likely to be superseded by proposed bipartisan legislation. Although that's been a roller coaster, we're optimistically expecting that it might be this year or perhaps early next year. Two of the interesting issues, though, in the DOL RFI is the DOL asks whether it should include corporate MEPs and affiliated service group MEPs within the definition of a single plan. And a corporate MEP is a group of employers that have common ownership, but not enough to make the group a controlled group. And the affiliated service group is defined in the 414M of the Internal Revenue Code. Neither of those groups right now are considered to be a single plan. If the DOL RFI is superseded by the legislation, one question I have is, could the Department of Labor issue advisory opinions interpreting the retirement MEPs to include these two types of groups? You can go to the next slide, Steve. And there's the corporate MEP and the affiliated service group. Next slide, please. This is also in a client alert from the Wagner Law Group of August 23rd, but I want to just give you one of the deadlines. The DOL issued this year a MEP reporting relief. It's in Field Assistance Bulletin 2009-01, and the DOL is offering temporary penalty relief for all MEPs not currently in compliance with the Form 5500 MEP requirements. And these requirements have been in place by statute since 2014, and MEPs are required to report a list of all the participating employers and their EINs, and a good faith estimate of the percentage of each employer's contributions, both employer and participant contributions, in relation to the total contributions made by all participating employers. And what the FAB will tell you is that there was a lot of noncompliance, whether by misunderstanding or not, maybe because there's some confusion about exactly which plans were entitled to be MEPs and who they should list on for their participating employers. But, and you can read more details in the client alert. The deadline, though, is if you are a plan that files in 2018, you get a 2.5-month extension to file. And what the DOL has offered is that, you can go to the next slide. Before we get to the bad apple, what the DOL FAB basically permits plans to do, if they file a 2018 that is in compliance, the DOL won't go back and assess civil penalties or require refiling for any of the 5500s from 2014 through 2017. So if you're a MEP filing 5500, look closely for 2018. If you comply, you're going to be in good shape. I wanted to just touch briefly on the IRS bad apple proposed regulation, even though we also have a client alert on this one from July 12th. This also may be superseded by pending legislation, but there are comments. If you want to make comments on the bad apple proposed regulation, they're going to be due on October 1st. And basically what the IRS bad apple proposed regulation does is it fixes the situation for multiple employer plans that are tax qualified under Section 413 of the Code who have had trouble removing non-compliant participating employers. And so it offers a solution for the MEP to be able to spin off and terminate that portion of its plan. But again, we're cautiously optimistic that the legislation may supersede the IRS bad apple. But if you're still interested in reading about it, it's in the client alert, and the comments would be due on October 1st. So the pending legislation that I've mentioned a number of times, I'm just going to give you the House Act, but it's been a bipartisan set of proposals almost since 2012, and now it looks relatively, it's relatively possible we will actually get this legislation. The Secure Act, which was passed by the House, would amend the tax code in Title I, primarily for open MEPs to be able to avoid the bad apple rule and under what's called a pooled provider plan. it also provides some protection for the Title I MEPs, like the association retirement MEP. And for the open MEPs, the participating employers have more responsibility than they might have, for instance, under the DOL's PEO retirement MEP. But there are rules with suggestions for both the IRS and the Department of Labor to provide regulations. So for the independent legislation, you can go on to the next slide, Steve. The employers retain a lot of the fiduciary responsibility, even though I think the pooled provider plan can be written in such a way to shift that responsibility to the MEP operator, to the pool provider, and there's suggestions in there. But I think one of the things about the legislation that's kind of interesting is it wants to make sure that the employers that are participating in the pool provider plan are not unduly restricted in transferring out money, and that they're not going to be unreasonable fees. Do you want to move on, Steve, to the next slide? There's one other piece of the pending legislation that some employers are interested in. If unrelated employers with their plans are on the same insurance platform, the Secure Act would provide that they could participate in a group arrangement that would rely upon a single Form 5500 filed by the Common Plan Administrator, and that would have a single audit. It's very similar to the group insurance arrangement for welfare plans that also currently is allowed to file a single 5500 for all the employers that participate in the group insurance arrangement. So that's something else we're looking at. So those are all my remarks.
Okay, great. Thank you. Any, is it possible just to give a very, very quick comment on what you think might happen between now and the end of the year in terms of legislation or litigation?
Yes. In the litigation for the association health plans, for the AHIPs, and for the association retirement plans, we're thinking the oral argument is in November. The government asked for expedited treatment of this case at the Court of Appeals level. So we're thinking that the resolution could come very quickly. And my best guess is at least part of those requirements will be upheld. The working owner question has sort of a statutory set of complexities, so I'm not sure about that part. But I think for the expanded rules for which associations can sponsor a MEP, I'm fairly optimistic about that. And oddly, I'm fairly optimistic, we're all fairly optimistic, that the House Secure Act, which provides open MEP relief, is likely to be a similar bill is likely to be passed by the Senate, if not by the end of the year, but closely thereafter. So we're going to remain optimistic that both of these issues will have a resolution fairly quickly.
Oh, that's great. Thank you so much. That's a really dense, complex area, the MEP. So thanks for for breaking it up and unpacking it for us a little bit today and keeping us current on what's happening. Mark, I'll turn to you for just any kind of latest, hot tips or issues in the world of executive compensation.
Sure, Steve. Thanks. I'll keep it general for us as we move along. If you look at this frame, you'll see, in some respects, some dire warnings in terms of a reflection of the current predictions for a recession in 2020 or some type of a downturn. But really, from an executive compensation perspective, I think the message is readiness. And that's in the sense that employers, whether they be private companies, public companies, or tax-exempt organizations, ought to be using the last part of 2019 to look at their executive compensation as well as their employee benefits overall in terms of the structures they have now, and then also whether they can be improved to position for future market volatility as well as, the impact that a downturn could have. The good news in some respects is that many of us have enjoyed over a decade of steady business growth as well as stock appreciation for public and private companies. In some respects, that lulls you in the sense of security because, the rising tide tends to lift all the boats, and that is the case in executive compensation. We've seen significant increases, mainly, or I should say, and largely due to stock price appreciation. So now as we look at the future in terms of what we can do, I think getting, ready for volatility or a downturn, this frame gives you just a laundry list of a few items. I'm not going to go through them in detail in view of the time, but here are just a couple threads to take away. One involves employer stock and equity-based awards, such as stock options, restricted stock, and RSU. At executive levels, these awards tend to dwarf cash compensation over the last 10 years and to rise every year. I think that you hear a lot about investment diversification being smart. The same is really true for executive compensation. It's often possible to convert stock awards or employer stock investments within plans or ESOPs into some type of a deferred compensation device that has a different rate of return from employer stock. And that way, even if a company is performing well from a profitability or industry side, but a market downturn hits hard, they can be ready to have diversified the downside risk for executives if they diversify out of the pure stock-based measure for rates of return. From an employer perspective, the introduction of executive compensation changes can be coupled with very smart business protections, such as imposing or refining covenants relating to trade secrets, non-competes, and non-solicits. So it can be approached as a win-win. The best thing to do, of course, is to take action before a downturn hits. One other thing to think about in terms of being proactive, it's possible to terminate stock awards as well as non-qualified plans. Often companies look at it and decide, this is a good time to cash out or switch to a new vehicle. One limitation under 409A says that you cannot cash out a non-qualified plan proximate to a financial downturn. So as a result, while times are good, that is an opportunity to terminate plans that aren't working or have, in some respects, fully utilized their useful life. Finally, the last item I'll mention, or the next to the last item, Rabbi Trust. They provide what's called change of heart protection. They don't provide a protection against an employer's bankruptcy, but something else happens in tougher economic times. Often there can be disruption or stress in the employer relationship, that is between employers and executives. Rabbi Trust and the protection they can have by putting funding benefits into a separate trust independent of the company can actually provide excellent protection that gives peace of mind, even if it's not pure bankruptcy protection. The last bullet here about pre-bankruptcy planning and risks, frankly, comes to mind because in some respects we've had such great growth for 10 years, people probably forget about what the risks can be. But one of them that I'll mention derives from what Tom Clark was talking about in terms of Department of Labor and its audit function to protect participants. But at the time, if there is a downturn, one of the first things that tends to happen is 401k accounts get hit, and the fiduciaries, often executives, start to get second-guessed in terms of were they monitoring investments properly. Like Tom said, it's the minutes of meetings and the documentation that supports and shows diligence that protects executives by showing they've been diligent and monitoring investments. And this is the right time to get that covered in terms of assuring that the record shows proper monitoring from an ERISA perspective when executives are serving as plan fiduciaries. Steve, we can go to the next frame. Yeah, social good is intriguing. I don't think it's on fire out there as a consideration, but you'll see this reference to ESG. That's short for environmental, social, and governance. These are like soft factors that companies are starting to look at when they put together executive compensation. This past summer, the Business Roundtable issued a provocative statement saying that corporate boards don't necessarily have to focus singularly on stockholder issues, but instead should look more broadly at how their companies are going to benefit not just stockholders, but also customers, employees, communities. And that statement has had companies thinking, well, how should the incentive plans at companies reflect these softer societal goals? Pearl Meyer just released a report that I thought had a very astute observation, and it basically said, companies are putting their toes in the water to revise plans to take into account societal issues and ESG. But at the same time, it's being done both in a small way, gradual way, and also that any action in this way really does involve intensive exercise, careful thought, and analysis, quoting from what Pearl Meyer said. As a result, the current trend is some small weighting of the ESG, but this is a topic, frankly, that's emerging and something we're tracking. That leads me finally to just mention that on any of these executive compensation topics, we're delighted to answer questions and inquiries, and we do have a wealth of information as well as survey data available for clients and listeners if they want more information about any of these topics. Steve, back to you.
Okay. Hey, thanks, Mark. Really appreciate it. So just very quickly, because, Rabbi trusts have been around for a while, and I know they still have a lot of utility. They're still used. It's not just a downturn tool, is it? I mean, there are other places where you like to put Rabbi trusts, correct?
Oh, you're right. Anytime an executive is signing an agreement that involves a future payout so that they're trusting that the employer will make the payout, a Rabbi trust can be significant. So it could be in a severance situation where payments are going to be made over time, especially, for example, if the company might be a target of selling out. And then also any type of a change of control situation, the executives of the seller will almost always get better peace of mind to have their severance pay and other post-closing compensation put into a Rabbi trust that's held by a separate financial institution rather than to rely on a buyer that they don't know to basically exercise good faith down the road to pay out the money. So that's an excellent point.
All right, great. Thank you. Okay, so we're going to move to the final segment of our webinar, which I will handle. I'm laughing. I'm remembering the times when I speak in front of live audiences, and I'm right before lunch, and it's a little bit hard to sometimes to get people's attention because their appetites are taking over. I also know that we're running a little bit long, and some people might need to step away. This webinar is recorded, so you can come back and hear everyone out on it, or you can send us questions. But I'll try to be as succinct and brief as possible. I just want to throw out some key points. So let's see how I do in terms of getting right to the bottom line on a couple of key issues. I think, first of all, just generally speaking, what's up on the DOL regulation? Well, we know they said they want to align with SEC on regulation best interest. They want to collaborate with them. We think that that's going to happen. That's what they've been saying in their speeches. That's what we hear. So it remains to be seen, but that's the direction that the next iteration of the fiduciary regulation is anticipated to be taking. One note, and it's still on the regulatory agenda, as a proposed reg for December of this year. So we're getting close. And that's what we're hearing in the email press, all the client alerts and little blogs. People are still talking about being about 2 months away now. So we shall see. I think it's really important that the fiduciary reg and Reg BI, if you will, are kind of meshed together to the extent they can. One interesting observation, one thing to note, I guess a few days ago on October 1, they did a reorg at the EBSA over at the department. And in effect, what they're really saying is that the political oversight, the political leadership is going to have a larger, broader voice. The responsibility, the Deputy Assistant Secretary for Program Operations, that role is going to change substantially. That's the role that traditionally, Mr. Hauser had for many years. So I think, what does that really mean? All the political pundits have their ideas and views on the reorganization and who's now covering what region and so on and so forth. My sense, I think someone mentioned earlier, and it might have been Tom, or maybe it was Izzy, I don't recall, but one thing you can say about this current White House is there are certain areas where they do want to act and they do think government should take a role. I think it may well be that with the political calculus being given a little more leverage in the department in the next couple of months, we actually might see the fiduciary reg, move a little quicker. There might be more, impetus to keep it moving, provided it's in a direction that's, friendly to maybe a little more friendly to the business community. I don't know. Those are just kind of off the top of my head, but that's kind of what's happening on the fiduciary reg. We'll have to wait and see what happens. I also want to remind everyone we also still have in tandem on a parallel basis, the states have taken a lot of action. There's not been anything particularly that I would point out to you of late, over the last couple of weeks. I mean, a lot of the states have various proposals. We're at a point now where it's really interesting to line them up and compare them. Like the duty owed, like in Nevada, it's a fiduciary duty. Massachusetts says it's a fiduciary duty. New Jersey describes it as a fiduciary duty. New York, the New York, the insurance reg, Regulation 187, they define it more in terms of being best interest, so on and so forth. So there will be some variations among these state initiatives, even though they all are sharing the same theme. And we'll just have to see how that plays out. I think another interesting thing is like you all remember the fiduciary reg had a private right of action. It was very controversial, hotly debated. Kind of at the state, where are we now in terms of private remedies? Well, under the federal law, under the federal laws, there's a limited private right of action to recover fees. There might be some other private rights of action under state common law. The SEC is saying that there's no private right of action or rescission, at least with regard to regulation best interest. Nevada says that financial, service providers, broker dealers, and sales reps will have to have they'll have to have the burden of proof on arbitration, that there's an exemption to the fiduciary duty available to them. There's no private right of action in Massachusetts or New Jersey or New York. So again, we'll see. There's going to be a bunch of differences. It'll be kind of fun to watch. And to me, the million dollar question is going to be, how does this all play out in terms of state preemption with federal law? That's going to really be an interesting thing. That's kind of one of the issues lurking in the background. What rights how can the states legislate in this area when we have arguably or potentially overarching federal law? So I think preemption is going to be a real interesting question. Now, the thing I wanted to really focus on a little more today is regulation best interest, but not so much as to what it's all about. We've had client alerts and other things on that. But one of the questions we're getting is, what should we be doing now? Our firm is working with some firms on Reg BI for implementation. We have other clients that have a wait-and-see attitude. So are we in irons? In irons is a sailing term when you're pointed directly into the wind and you're just fluffing away, going nowhere. And I think a lot of people feel like they might be in irons right now. Should we get involved? Should we take some action? Should we wait and see? There's a little bit of built-up resentment of all the time and effort that was spent on the fiduciary reg and money. Then it was vacated. Gee, we don't want to do that again. But by the same token, it wasn't that bad an exercise. We learned a couple of things. Our best advice to clients is that better to be prepared than caught unawares. I know back in the 408B2 days, a lot of firms, especially on the broker-dealer side, waited too long to take action, and they got crushed as we approached the implementation back in August of 2012. Advisors were better prepared. So, with some of our clients are ahead of it right now, and they've organized some working groups and have work streams. Smaller clients function a little differently, but our larger, more institutional clients, a few of them have some work streams going. They've kind of identified, who's going to be on the team, the players, so they're calling on different people from, product development and operations, the HR department and compliance department for training and policies and procedures, operations people, the technology people also are getting involved. So they're cutting across different elements of the firm and putting together the right teams. And the issues, obviously from just in terms of opening new accounts, how do you identify retail customers that are subject to Reg BI or to CRS? And where is this information and how are you going to get where's the information going to come from? How are we going to get it to them? What's it going to look like? Just the whole product, just really doing a self-inventory on all your products and services and the different fee streams, direct and indirect. Just operationally following a new account through the process or a trade being executed or a recommendation being implemented. How does it work? All the marketing stuff, the promotional material, the client communications, payout grids for compensation, any conflicts, what kind of issues we have there. You have a little bit of a playbook in place from the DOL. For those of you that kind of remember the way you organized and sliced and diced the issues and how to approach this, the fiduciary reg, to the extent that you went through thematically and systemically, is probably not a bad template to kind of think about how the regulation best interest might lay in. This is a little more prescriptive as compared to principles-based, I think. So even though it's pretty complicated, there'll be a lot of questions and a lot of soul searching on how to best implement it on a relative basis. It probably will. At the end of the day, once you get started, it'll probably feel a little easier and a little quicker, to work your way through. I think one of the big challenges people are going to have is identifying retail investors and retail customers. I know from experience, one of the most common errors we see at our big at clients, large and small, is failure to properly identify and categorize ERISA versus non-ERISA clients. What kind of plan do you have? Is it subject to ERISA or not? Is it qualified by the tax code? Because that has implications for different policies, right? I think the same thing here. I think people are going to have to really make sure they really get a good grip around retail investors and retail customers and how that all works. And they're going to need to really know through all their business lines if and when it's possible for recommendations to be made, and what happens if a recommendation is followed. Does that trigger any conflicts, from proprietary products or, multiple income streams, direct and indirect compensation? So a systemic and systematic review of, a little inventory of where are you, how this might hit you. The time's a wasting. We're getting into October now. It's going to go quickly. So I think it's a good, worthwhile exercise to go through. The wait and see attitude will probably hurt you in the end. And then you have to think, once you figured all that stuff out, you have to figure out, okay, how do I actually comply with this thing? I mean, we've got, all the different kinds of disclosures that I have to make. And I think it's good to maybe, have some sort of gap analysis started right now. What kind of disclosures do we make? Are they robust and complete enough? Are we far enough, are we going to have to tweak them at all? How does this all interact with suitability and know your customer type rules? Where does regulation best interest come in with that? How do you satisfy all the different conflicts? What are our policies and procedures that are in place? What are we going to have to adopt for the future? How are we going to implement them? A lot of work to be done. And I think that, and then training your people how to go out and sell and present on behalf of the broker-dealer firm. I think it's also interesting, even though this doesn't apply, CRS, of course, will apply to investment advisors, but even though the regulation best interest doesn't apply directly, I think it'll become a benchmarking point. I think when investment advisors are looking at how do we discharge our fiduciary duty? How do we know that we're how do we know that we're meeting our duty to clients? My guess is that there will be some leakage, some benchmarking that kind of comes over from the regulation best interest broker-dealer side of that. So then, of course, you also have the record keeping, and how you're going to keep up with all the record keeping requirements for regulation best interest, and what kind of technology support do you need there. So there's a lot. Those are just for people who think it's not going to be that hard to do. I'll wait a little while longer. There is a lot of stuff to get organized around. It's probably best to put together at least mapping out implementing a work plan, mapping one out, and getting it started. And kind of wait to see what happens. Now, there have been some lawsuits filed. There have been some legal challenges over the last week or so. So let me tell you on that. There are those that say, well, gee, maybe this thing will never come to the fore. Maybe regulation best interest will be vacated. I'm not smart enough to pretend to know. But I can tell you that there have been 2 lawsuits filed, and they challenge regulation best interest. One is titled, let's see, it's the state of New York versus it's 7 states in the District of Columbia. It's the state of New York versus the SEC, and then there's another one that was brought by a group of financial planners. That are working, under registered investment advisors, and by one of its members, and that's called XY Planning Network, the SIC. They challenge regulation best interest. They don't challenge the requirement, to provide relationship summaries or file CRS. They don't challenge the interpretive guidance on what the fiduciary duty is under the Advisors Act, or what quote incidental means for purposes of the need to register as an investment advisor. And in fact, what both these cases are doing, what they're really saying is that they're really looking at the Dodd-Frank Act, Section 913G, which had authorized the SEC to issue rules to provide that a broker-dealer providing advice, personalized advice, to a retail customer, about securities should be subject to the same standard of conduct as that that was applicable to an investment advisor, and they're trying to close that gap, harmonization. And I think what these suits are saying is that it's because the Reg BI doesn't follow the grant of authority specifically, the way it was laid out in Dodd-Frank, therefore, ergo, it exceeds the SEC's rulemaking authority, and it's not in accordance with the law. And they also say that it's arbitrary and capricious. So we'll see what happens. They didn't seek a preliminary injunction or any other relief or to suspend compliance until the suit is resolved. So we'll see what kind of shapes this litigation takes. We'll see if there's another shoe to drop shortly. Maybe there's more litigation coming. That could always happen as well. But I think the takeaway here is for firms is that June 20 is going to come really fast, and you ought to be doing at least some preliminary planning and organization around regulation best interest. We've been doing it with some clients. We have some that are waiting, but we have a lot of clients that are beginning to begrudgingly, sometimes begrudgingly, sometimes warmly, just accepting the fact that it's something that needs to get done, and it needs to be done in a thorough, systemic fashion. So that's it for me. I want to thank everyone for attending our briefing today. We really appreciate it. On behalf of my colleagues, thank you very much for being here. Let us know if you have any questions. You can contact us through the email addresses you have, or just call one of the offices and run us down. And we'll look forward to seeing you at our next benefits brief. Thank you so much.